um, they act bizarrely, they make statements that are irrational, that don't make sense, and they oftentimes tend to blame themselves for whatever has happened. I've seen this many, many, many times in the emergency department.
Does this happen moments after a stressful event?
Oh, yes.
Does it happen months later when you go on 20/20 or Nightline?
I've never seen that situation.
Yeah, no. Does it happen a year later when you go and speak to documentarians and be interviewed? Is that the same kind of condition you see a year later, a year and a half later?
A grief reaction can last years. It usually is very brief, but it can last years.
Now, when you looked at the clothes in this case, Mr. O'Keefe's clothes, you are aware that those clothes were swabbed for DNA traces, weren't you?
Yes, I'm aware that some of the clothes were swabbed for DNA.
Right. Could we have Exhibit 147B, please? On the right arm, there were a number of different tears in that fabric that you looked at, weren't there?
Yes, there were a number of small round holes in that
You're
fabric.
aware, aren't you, that those holes were swabbed for traces of dog DNA?
Objection, Your Honor. I'd like to approach, please.
Okay, come on up. Continue what we're doing, but we will give you the morning recess. So that's about a half an hour or so. Okay.
All rise for the court, please. Close your notebooks. Follow me.
Dr. Russell, you can step on this.
Oh, okay.
Thank you.
Ma'am, watch your step coming down. Follow me.
Jury is exited the courtroom. Please be seated.
All right, Mr. Alessi, I'll hear you. Mr. Alessi, I'll hear you.
Thank you, Your Honor.
Excuse me, Mr. Brennan.
Mr. Brennan, can you remove? Oh, okay, it's being removed.
Thank you, Your Honor. Attorney Brennan, just with regard to Dr. Russell, in open court in front of the jury, used the concept of DNA in this case. He has introduced it and brought it in for the very first time in front of the jury. He has done so intentionally. He intentionally brought up DNA. Based upon that intentional mention, the defense moves strongly, vigorously for a mistrial with prejudice. A mistrial with prejudice. There has been no mention in this trial of DNA with regard to the topic, with regard to what Mr. Brennan has raised. There has been none. Specifically, the prosecution had, in the first trial, had a witness, Terry Kuhn, with regard to DNA. For whatever reason, the prosecution has chosen not to bring that witness in who would testify perhaps to DNA. As a result of that strategic decision that the prosecution made, there's been no mention. I want to be very clear. The defense has been incredibly assiduous and meticulous about not mentioning DNA in any fashion, directly or indirectly. With regard to the hoodie shirt and the hole, the only thing that was adduced in direct examination was a mechanical function simply of Dr. Russell testifying that a dog tooth went in and came out and caused a certain mechanical effect on the yarn. Nothing even close to the mention of DNA. With regard to representations that Attorney Brennan has made that somehow there was a hearing that we were on notice, it is completely incorrect. Show me the hearing, show me the transcript where that has been discussed. The prosecution has also said, we're going to, or we always intended to bring on rebuttal Dr. Crosby, who would talk about the supposed absence of DNA, the alleged absence of it. The problem with that of trying to rescue the mistrial that the prosecution has caused with prejudice is that Dr. Crosby could never testify about such a topic, because I would object and object because there would be no foundation, because the prosecution strategically chose not to bring in the foundation whatsoever in this trial. The fact that they did it in another trial, or perhaps did it, is irrelevant to this trial, as Your Honor has admonished several times. What happened this is a new trial, and whatever happens in the first trial is the first trial. So in conclusion, Your Honor, because of the conduct of the prosecution, and specifically the intentional mention of DNA, the prosecution has put in the jury's mind that topic that is irremediable. That cannot be reversed. That cannot be cured. That cannot be ameliorated with a jury instruction. That cannot be dislodged. The prosecution has to suffer the consequences of its own intentional actions of bringing up that topic. Ms. Reed is entitled, under the Constitution, under the Massachusetts Declaration of Rights, to a fair trial. And what has just happened is antithetical, abhorrent to a fair trial. The only remedy is a mistrial with prejudice.
Okay, thank you. Mr. Brennan?
Inquiring of Dr. Russell about the absence of dog DNA is not only proper and permissible, it's essential, and the Commonwealth is entitled on cross-examination to explore theories and facades that the defense creates if there is actual evidence that undermines or contradicts the representations that they are trying to portray to this jury. Let's be clear. The defense is on notice that there is no dog DNA in the sweater of John O'Keefe. Let's be clear. The defense is on notice that we were not going to try to disprove all of their varying theories in our case in chief, but if they were going to propose theories that we thought were unsubstantiated, we would do so in rebuttal. It is clear these witnesses are on the witness list. More so, the conversation and examination of Dr. Russell is replete in the historical record of this case. Dr. Russell herself testified on December 12, 2024, that she did consider the absence of DNA in her opinion. She disregarded it, she discounted it, she created false theories about the potential destruction of it, but she did testify this was part of her consideration for her opinions. Again, on January 7th, 2025, Dr. Russell again discussed the absence of dog DNA in John O'Keefe's sweater. Now, it may be inconvenient, it might be hurtful for the defendant's theories, for the creation they portrayed for this jury yesterday, but it is not improper, it's not unconstitutional, it's not irrelevant, it's very relevant. It is powerful evidence that the Commonwealth has to undermine this idea that the linear, superficial abrasions on John O'Keefe's arm were somehow caused by a dog. They, on their case in chief, tried to create impressions about the cause of the abrasions to Mr. O'Keefe. The defense does not get to pick and choose what words the Commonwealth can or cannot use. They do not get to pick and choose what parts of Dr. Russell's opinions are important and not important. Because they chose not to emphasize, highlight, or discuss the absence of dog DNA on direct does not mean it's beyond the scope of direct examination. It means they did not want to talk about it because it was not helpful to them. There have been countless cross-examinations in this case where questions are asked beyond the scope of direct. This is not beyond it. It goes to the heart of her opinion. If I cannot cross-examine her, as proposed by the defense, about the heart of her opinion, she shouldn't give it. She shouldn't have an opinion, because you can't come in and just take the favorable factions for yourself and leave out reality. I intend on asking Dr. Russell about her opinions, about the role that the absence of DNA played. Also, I expect to ask her about her attempt to diminish or demean the DNA evidence, because it shows her inherent bias in all of her opinions, where she acts as an advocate, not as a scientist or a doctor. It is admissible evidence. We intend on using it. And when she returns to the stand, these are the very questions I'm going to ask her.
Your Honor, may I have a brief 1 minute?
Sure, go right ahead,
Thank you,
Mr.
Your Honor.
Alessi.
Your Honor, a key misstatement of fact that Attorney Brennan just made. He said that Dr. Russell talked in prior proceedings and hearings about dog DNA. The record is abundantly clear. She only did so in response to a question from Mr. Brennan. I have the transcripts right with me. She never raised it affirmatively. She gave her opinion that these wounds were to a reasonable degree of medical certainty from a dog. Mr. Brennan on cross said, did you consider, and this is in a prior proceeding, did you consider DNA? She gave her answer. She didn't raise it. I heard it. I was there. Your Honor was there. So this impression that Mr. Brennan is trying to give, that somehow the defense brought this topic up before, is incorrect. The second point, Mr. Brennan needs to have a good faith basis to ask the question. To have a good faith basis, he has to have some admissible evidence that he's got for it. He has no admissible evidence on dog DNA with regard to the arm. He knows he doesn't. He strategically chose not to bring that evidence in this case. Now he's saying he wants to use it. That would be improper in this trial for that reason. The other 2 points quickly. Mr. Brennan alleges an absence of dog DNA with regard to these wounds in the right arm. There was no swabbing of the wounds of the right arm of Mr. O'Keefe. That is a major, major investigative flaw in this case. That should not be befallen upon the defendant. Secondly, there are, with regard to the hoodie that was one, I believe, swab taken, and we don't know much about it, but what we do know about it is there are horrible, tremendous chain of custody and care with regard to the hoodie, conceded, virtually left on the floor of the ambulance, left on the floor of the hospital, carried around by Mr. Proctor for weeks, maybe even months, not submitted for testing for months. There are huge issues that prevent a fair determination about whether there was even proper determination of whether there was DNA or not. So in conclusion, Your Honor, the defense has never brought up DNA or alleged absence with regard to the right arm of the hoodie. It's always been the prosecution. We were meticulous and assiduous in not doing it here. The prosecution needs to live with the consequence of its action. This is remediable, and I respectfully submit warrants only one ruling respectfully, and that is this trial must be declared a mistrial with prejudice.
May I have 30 seconds?
Sure.
The defense can pound their fists and yell as loudly as they want, but they can't change truth and reality. Whatever the motivation is for wanting a mistrial can't be based on a claim that the prosecution raised DNA for the first time with Dr. Russell at the Lanigan hearing. If we actually look at facts and reality, rather than making false claims about everybody in the courtroom and everybody else who comes in here, what we'll see in the transcript, and this is the December 22nd, December 12, 2024 transcript, I direct the court to the direct examination of the attorney who just accused the government of raising it for the first time. Despite his words,
what page
we have page 83, line 21. We have page 122, line 14. We have page 124, line 14. These are the words of Attorney Alessi on direct examination. And there are more. There are more. But that is enough for the court to understand that the representations are wholly mistaken by Attorney Alessi. Wholly.
All right, thank you. We'll give everybody a half an hour. So
All right.